Secretary of State's records retention requirements. There was some confusion in the June meeting as to what the requirements were. Staff was sent out to prepare a resolution that found out what the requirements were, and they passed a proper records retention requirement. There's no misconduct whatsoever here. And all the commissioners voted for Resolution 10-3. The next part of the allegation alleges some sort of cover-up. There's no cover-up here. There was the minutes that were attached disclose exactly what happened, that staff had inadvertently deleted a recording of a prior meeting, and they couldn't recover it despite the efforts of the executive director to recover that. But that's a staff issue. Where's the conduct of Commissioner Hupp that constitutes malfeasance, when he's the one who is voting to preserve the records for 6 years? It doesn't explain what constitutes malfeasance, and so therefore it's factually insufficient as well as legally insufficient to support a recall charge. The next allegations I want to talk about, I want to address numbers 3 and 5 together, because that concerns the emails that were the subject of this case. There are 3 different emails that are alleged to be specific violations. However, if you look at those emails,
all right, let's just look at it. Let's just.
You'll find that those don't support a recall charge.
All right, let's look at the.
Let's look at each one. The first one is the May 29th email. The May 29th email.
Hold on.
Your Honor, if I may, the supplemental briefing we provided gave cover sheets with all of the allegations. It's on your left.
Thank you. Which tab is it?
Unfortunately, the tabs don't refer to allegations, but if you go to a cover sheet, it says allegation number 3.
Yep, I do.
Okay.
Thank you. Thank you so much, Kirsten. This is helpful. Okay, I have it now, Counsel. You can proceed.
Your Honor, that email is an email that Commissioner Hupp sent to several people, including his friend Tom Wallachner. It says you have to watch the attachment. I didn't know how he did it without cracking a smile. And that is the entabulator attachment. You'll see up there in attachments it says entabulator WNV. Entabulator is a joke. I've got it loaded up here on the screen if you care to look at it. It's a humorous video that was simply forwarded from one commissioner to another. How is that any basis for recall?
We'll watch it.
Your Honor, do we need to continue?
No, but I guess I'm going to turn to you. This was attached as to this email, his response. This email looks like it was not original, that it went from a John Krause to Mr. Hupp. Mr. Hupp then sent it to these other people. Is that correct?
I believe that's correct, Your Honor.
Along with this attachment. Is that correct?
That's correct. It simply is forwarding on something that was intended to be humorous. It doesn't address any of the court's public business. It's a friend sending a friend a humorous attempt. It's not misfeasance, it's not malfeasance, it's not a violation of anyone's oath of office. But what's not humorous is that we have now been, a recall is being sought because, on this basis. So let's look and see whether some of the other emails are a basis for recall. Let's take a look at the June 18th email. The June 18th email is again a forward from
Hold on just a minute. Okay, go ahead.
a forward from Commissioner Hupp to Tom Wallitner and Commissioner Miles, as well as the Executive Director, Mr. Dobson and Wendy Smith.
Okay, hold on. I have the June 18th, 2007, or 2010, 7:47 a.m. Is this what you're referring
Yes.
to? Okay, thank you. Go
And
ahead.
what Commissioner Hupp did is he sent FYI a forward of an email string where he was corresponding with Jim Gaston.
Who is Mr. Gaston?
Mr. Gaston works for Dodge, the incinerator folks.
Okay.
And he informs Mr. Gaston that the plan is to have a special meeting to deal with the 2 lease extensions. And he is simply passing on that information to Mr. Wallitner and Mr. Miles. There is no discussion going on between Commissioners Hupp, Wallitner, and Miles. There is simply an FYI about what is going to happen at this future special meeting. The Open Public Meetings Act has a provision that when you call a special meeting, you are required to notify your other commissioners of what the contents of that special meeting is going to address, what the subject matter is. And it specifically allows that to be done by email. So this is not legally sufficient to support a recall charge, because all that's happened here is that Commissioner Hupp has notified Commissioners Wallitner and Miles what's going to happen at the future special meeting. And they're not discussing the lease extensions. It is simply a forward that was passively received by Commissioners Wallitner, Miles, as well as Dobson and Smith.
Okay,
So let's look-
Wallitner is the other commissioner, and Huff is the commissioner, right?
That's correct.
This went to Walton for your information. Why, did he send it to the other commissioner?
Yes, this one is forwarded both to Commissioner Wallitner and to Jack Miles, Commissioner Miles.
Okay. So it went to the other commissioners.
And simply tells them what's going to happen at the upcoming special meeting. That's not a violation of the Open Public Meetings Act.
All right. Keep going.
So let's take a look at the third email. And this one is printed out on a sheet that says 3 and 4 of 26, and was attached to the petition. It's got a date of 8/23/2010 at the bottom. It's extremely small print, at least my version was.
I have to keep going.
Your Honor, if you look at this, you will see partway, or at the bottom of the first page, there's an asterisk written in the margins, and it says forward existing boiler emissions. And then it says John D.
No, I lost you. I have boiler, electricity, generator, dock. Where are you looking? Okay, forward, existing boiler emissions. I have that.
Right, and it's down at the bottom of the first page.
Go ahead.
You'll see that this was sent on July 31st, 2010, as the petition alleges. It was sent to Jay Hupp. It was sent to Commissioner Wallitner. It was not sent to Commissioner Miles.
But it was sent to Wendy's.
And it was sent to Wendy Smith, who is a staffer at the Port Shelton.
Okay, so it was sent to 2 of the 3 commissioners.
2 of the 3 commissioners.
All right.
It was sent by John Dobson, the executive director of the port. Commissioner Hupp did not do anything here. He simply received an email. And as the Wood versus Battleground School District case tells us, passive receipt of an email is not a violation of the Open Public Meetings Act. If you look at the rest of these email exchanges that were attached to the petition, None of them involve Commissioner Hupp. There is an email from the court's attorney, Skip Hauser. There are various emails from Mr. Dobson to Wendy Smith, from Jerry Erickson to Mr. Dobson, and from Mr. Dobson to Northwest Salmon at HCTC, which I believe is Mr. Erickson. But none of those involve discussion of the court's business. None of them show deliberation between Commissioner Hupp and Commissioner Wallachner. All you have is Commissioner Hupp and Commissioner Wallachner receiving the same email from Mr. Dobson. There's no action taken. It simply is legally insufficient to violate the Open Public Meetings Act. Now, the charges here are required by statute to identify the date and time and acts committed. And we have the 3 emails. In support of that was submitted the auditor's report. The auditor's report was a year earlier. It certainly cannot be probative of violations in 2010 when it was drafted in 2009. So the auditor's report is irrelevant to determine whether or not the May 29th, June 18th, or July 31st emails are violations. They're clearly not. Charge number 5.
Well, let's go to charge number 4.
Okay, we can go to
This
charge.
is the one of handling the overflow crowd that was anticipated. And what they are saying to me is that the rules that he did applied to some people, but didn't apply to all people.
There are a couple of allegations there.
The overflow and how he allowed it to continue. Go
Right.
ahead.
And I think you need to understand the factual allegations that the petition itself makes. First, there was a meeting on August 3rd. And at that meeting on August 3rd, somebody said, you're going to need a bigger room, because this is an issue of great public interest. And the suggestions were then brought forward by Commissioner Hupp. Well, how are we going to deal with that? And he said, well, if we have too many people, and people are waiting outside, we'll just have the people who have testified exit and bring in the people who haven't testified. There's nothing one-sided about that type of rule. It facilitates people's right to comment. And just so that you're aware of, there is no statutory or ordinance requiring the court to hold any comment. The court was trying to be open and transparent and get public input, and it was successful in getting public input because 47 people came and signed up to testify concerning the lease documents. So when the court advertised, what is it that you want to have public comment about, it said, we would like you to have comment about the lease documents, the resolution, the lease option agreement, and the land lease itself. And so at the beginning of the hearing, there were rules that said that's what the topic is. Please cite to the specific lease provisions. And then Commissioner Hupp turned the meeting over to the attorney, Mr. Hauser, so that he could preside as they were taking comment. Mr. Hauser asked people to focus on specific provisions. And perhaps there was some latitude given